and it's a great honor to be here to moderate this panel. We have three absolutely tremendous speakers on the panel. We're not going to have long introductions of them. Jim DiDonato is with Beasley. Robin Cohen represents policyholders with McCool Smith. Joe Monteleone represents insurance carriers with Rivkin Radler. They are probably all personally known to many of you and by reputation to the rest. So let's start out by asking what makes coverage disputes involving London special? Let me ask our panelists to comment briefly. What is it about the role of the broker that makes mediating cases with London special?
In the London market, unlike in the U.S. or most of North America, the broker is more or less a true intermediary, whereas in the U.S., the broker should clearly be aligned on the side of the policyholder. I know that I, as insurance counsel, do not usually view a U.S. broker as my ally in a coverage dispute. If anything, they should be aligned, and I respect that, on the side of the policyholder. But in the London market, they are more of a true intermediary. When I first started doing work in the London market, I was shocked when someone would say, well, if you have a potential rescission issue, turn it over to the broker to do an investigation. Where in the U.S., I would say, why? I'm letting the fox into the henhouse. The broker is not on my side. Why should the broker be doing the rescission or any other coverage investigation? So that's the primary difference between the U.S. and the London market. That being said, in both cases, the broker can have a very influential and helpful role. It's just important that you know what the broker's biases may be.
Robin, does it seem the same way to you?
It does. I think the London brokers tend to be more effective in the mediation process. They're able to maximize the business relationship a lot more. We have been able to utilize them from the policyholder's perspective in a way that gets to a resolution quicker, or at least gets to a resolution at a certain point. The U.S. brokers have not been, in the very large cases, haven't been as effective in helping get results.
Jim?
Yeah, from the claims handling side, and as pointed out by both Hank and Julian in the prior presentation, the London market is still generally a relationship-driven marketplace, and the broker is really kind of the kingpin in it all, because they direct the business, both for the insurers and for the clients. Handling risk through the London market from the broker's perspective, we sometimes have to deal with two. The main broker is the London broker who places the business with Lloyd's, but in the U.S. there is a retail broker who will also, depending on their sophistication, will get also involved in the claims. And to Joe and Robin's point, they are very helpful intermediaries, although some are also very, very true advocates for their clients, which of course helps Robin out more than it would help Joe and myself. So it is a very, very unique relationship, and one that you have to take into consider really at the get-go of who the broker is and how they're going to be involved in any sort of dispute.
So
Jim, that's a good
Joe.
point, and that's exactly why even in the London market, I wouldn't delegate a rescission investigation to the London broker.
I mean, one thing you have to be very careful about is that if you involve the broker, often the communications with the broker are not privileged. We often argue that it should be privileged from the policyholder's perspective, and we often lose that argument. And so often the worst documents that we typically get from the policyholder side is internal documentation or emails between the broker and his supervisor. So at the end of the day, you always have to be thinking about whether the case is actually going to settle. A lot of the materials that we're talking about today are under the mediation privilege, but a lot of it isn't. And so you need to be very careful, on both sides, regarding what your broker says and to whom.
and to expect that at one level or another, the broker is going to be involved, and as you say, more actively than if you're dealing with U.S. markets. Okay. Now, the relationship of the lead to the following market. How does that change the mediation of cases with London?
I'll speak first. At Beasley, we primarily take a lead position within the market. We like to lead our business, particularly in the professional lines. It is critical if there is an insurance dispute or any sort of dispute relating to the risk to line up the market. So as Hank and Julian had talked about, you have a syndicate that leads the business on the slip. You will have a second lead, which is often, in at least the complex triage, an agreement party, meaning that all claims activities have to be agreed upon by the second. And then you may have a number of following markets who will have a portion of the risk, but will not have any say in the claims handling of the particular underlying risk. Now, when it comes to coverage, it's a little bit different. And you want to make sure that you are aligned with both the agreement parties and the following market before you take any action. In my personal experience doing this now 7 years, I've had a lot of success getting the market all lined up. Usually we're all on the same page in terms of what the coverages might be, but I've also had situations where the market's split, whether on the same layer or within the tower. And so that's something you want to make sure that you are aligned, and if you're not, how you're going to handle it, because it will disrupt the risk. It'll be disruption to the insured, and it'll certainly be a disruption to the broker and his business or her business.
Jim, any most important points on how you find that out, and one or two pointers what you do if that is the case?
Sure. I mean, first of all, if there's a coverage dispute, I'll first call my second lead, which is the other agreement party, get his or her agreement. We'll then float by email or we'll have a market call with the rest of the carriers on that layer to make sure that we're all aligned. And if we are, and we expect some sort of pushback from the policyholder, we will call the broker first and give that person a heads up of what our preliminary view of the coverage position is. And then at that point in time, it can take a whole different various routes. We may have to hire counsel. At which point somebody like Robin will get involved at the other side. If there's an internal dispute within the layer, I've had situations where the various markets will retain their own coverage counsel. So 5 or 6 of Joe and his colleagues will all represent the various carriers. And then, and I'm sure we'll get to it, how does the insured fit into all of this when the market is fighting between themselves? So,
But there's only one Joe, so why don't we ask Joe, what is your perspective? How does it look to you when this happens?
Well, I think one of the keys, building on what Jim just said, is to look at the policy or the slip to see if there's a claims control provision in there and exactly how that's worded. Because in the absence of a claims control provision, you have exactly the balkanization of the insurers that Jim just described. You have disputes among the insurers in the quota share layer. You have disputes through the various excess layers. Whereas if you have a firm claims control provision, hopefully you could count on the lead to speak for at least everyone in that quota share layer, if not for excess layers as well. Now, unfortunately, I've seen from my perspective, even where there is such a claims control provision, particularly among U.S. insurers, companies that may be participating in a slip, I've seen a lot of U.S. insurers tend to want to go their own way, retain separate coverage counsel, assert positions that are not necessarily consistent with what the lead is saying, and that's very unfortunate. And it doesn't always occur, but there are cases where it degenerates into that.
Robin, Joe says it's very unfortunate. Does it make your job harder, and how do you address it?
So I typically get involved when there is a dispute, and so it is pretty frustrating because in a lot of the larger cases that we handle, there is disputes dealing with a lot of U.S. companies and a lot of different law firms. And I'll tell you from the policyholder's perspective, what I do, unless I'm forced under the policy, I won't mediate or I won't even meet without an actual good faith offer on the table. Because that forces all the companies and the syndicates to get together and decide whether they're serious about trying to resolve it. So typically, I will advise our clients not even to meet until we know that everyone's on the same page and they're willing to put forward a good faith offer to settle the dispute. And often, if they don't, we try to get the broker involved. And if the broker can't do it, we certainly aren't going to be able to do it. Perhaps a mediator could do it, but if you can't, in our view, if you can't get the market to put forth a good faith offer, then typically we won't meet. I mean, my clients won't meet.
I was going to suggest
Please.
that sometimes in those situations, it actually makes Robin's job easier because the infighting between and among the insurers will be used to the policyholder's advantage.
That's really true, and also if we see that there is disagreements and we decide to file a suit, that puts pressure on the situation between the different syndicates and companies. And it actually, in some ways, a lot of my adversaries will tell me actually is helpful, because if it doesn't get resolved, the policyholder is going to push that litigation forward.
You know, I was saying, in many of these cases, I've told my clients when I was in-house, told my company, you know, if there's an effective claims control provision, your only recourse is to, in effect, vote with your feet. You don't like the way the lead is handling it, you get off the risk at the next opportunity, but you basically should be, in a sense, stuck with the lead's position for that particular claim.
Jim, final comment, or shall we advance?
No, I don't think I have anything else.
Okay.
Well covered.
The need to take consistent coverage positions. This dovetails with our last comment. What are the issues that come up there?
Well, I will tell you from the policyholder's perspective, we love when the carriers take inconsistent positions because that just says that the language is ambiguous, and we use that in the coverage litigations. I was lead counsel in the Vikings case that some of you know of, and in that case, what happened was the carriers were all over the place on what was the right allocation when you had a non-cum clause. And so we use that ambiguity against the industry in the trial court, which really helped us. And then when we ended up going to the Court of Appeals in New York, the inconsistency in positions was very effective with the Court of
Now,
Appeals.
how do you make sure that evidence is admissible?
We make sure we put it in the trial court, before the trial court. So it's really, I'm big on inconsistent positions. I think that's one of the best leverage points that a policyholder has, because you're trying to show an ambiguity. If you can show an ambiguity, at least in the U.S. courts, you typically win. And so to the extent there are inconsistent positions, and understandably so, because the carriers are sitting in different positions, that is very helpful to the policyholder.
So no hobgoblins of small minds allowed in your cases.
That's true.
Okay. Jim?
Well, I will say Robin's exactly right, and because of the uniqueness again of the London market, the small broker communities. I mean, I think you saw from Hank's presentation the map of all of the broker locations and their proximity to Lloyd's. It is a very, very small universe. And they all know what you're doing. And in certain of the lines, I primarily work in the A&E architects and engineers space. On the large firm risks, there's only a handful of brokers that play in that space. They know exactly what you're doing at all times, and it will come back to bite you. So you have to be very, very careful that you're taking consistent coverage positions.
I was just going to add, as far as inconsistent positions and giving rise to ambiguity in policy language. Typically, any good advocate on the insurance company side can argue against inconsistency. Language is different, particularly when you get to areas like professional liability and D&O, where you're not dealing with an ISO form. The language varies from policy to policy, even within policies issued by the same insurer. And a lot of disputes are very fact-sensitive. For instance, a dispute over whether or not there are interrelated wrongful acts. You don't necessarily get a lot of guidance from the court decisions, certainly because of confidentiality. You're not going to get any guidance from past arbitration results. So inconsistency is not so easily established.
Fair enough.
Jeff Kichaven is an independent mediator in private practice. For more information, please call 888-425-2520.